My name is Nurfadila Rosli, number matrix BB3310339, and I will present about the first issue, where our first issue is whether Won Bin committed check fraud by changing the payee name, and if Minho, who received the check, can be held responsible. Based on the case study, Won Bin, the manager of HB restaurant, took a company check worth 10,000 and alerted it. The check was originally made out to Sedap Basendrian Berhad, bearing the word not negotiable. Won Bin, nevertheless, clever alerted the pay name to his name using a special chemical ink, making it appear original. He utilized the set and used the check as a payment for a purchase of a television set from Minho. And then, Minho deposited the check to his account at Juta Bank. When the restaurant owner, Hyun Bin, discovered what had happened, he asked Minho to return the money, but Minho refused. This case touched on legal principle regarding the check as a negotiable instrument and whether changing the payee name invalidated the check. According to Section 64(1) of the Bills of Actions Act 1949, if the checks or bill is materially altered without the consent of all parties involved, it becomes invalid unless the persons who made the alterations had permissions to do so. In Won Bin case, he changed the payee name with authorizations, which invalidate the check and make him liable under the law. As for Minho, Section 64(1) also states that if the bill is materially altered but the change cannot be seen, and the check is held by holder in due course, it can be enforced as if it did not change, as per its original term. However, because of the not negotiable marking on the check, Minho cannot benefit for it. The effect of not negotiable clausing in a check is provided in Section 81 of the Bill of Actions Act 1949. Referring to Wilson and Minson versus Pickering 1946, in the case, an employee Wilson provided a closing check with the word not negotiable written on it and handed over his child to insert the payee name and amount. The check, however, absorbed such confidence by inserting an amount that was in excess of requirement and handed over the check to Pickering in settlements of his personal debt. Based on this case, the court held that the employer, Wilson, is not liable on the check because the check has been crossed not negotiable, and such means that any subsequent holder cannot have better title than the transferor. Regarding to the case, the court held that employer, Wilson, is not liable on the check because the check had been crossing not negotiable, and such means that any subsequent holder cannot have a better title than the transferor. Since the child did not hold a valid title in the check, neither could Pickering have received a valid title, though he would have been a good fight. Under Section 81 of the Bills of Action Act 1949, if one receives a check with a closing with the inscriptions not negotiable, one is not able to get better title than that of the giver of. In conclusions, Won Bin broke the law. He committed fraud and changed the check, which gone against Section 64(1) of the Bill of Action Act 1949 and make this check invalid. Minho might not have meant to do anything wrong, but he did not get a valid title to the check. The reason for this is the check originated from fraudulent activity and had a not negotiable marking, and Minho did not qualify as a holder in a due course. According to Section 81 BEA 1949, Minho needs to return the money to Hyun Bin, the rightful owner of the check. While Won Bin could face criminal charging under Sections 467 of the Penal Code for creating a fake valuable security. This often can result in person sentence of up to 20 years and monetary penalty.
So the next issue is whether Rupa Bank can be held legally liable for processing a check that was materially altered by Won Bin without Hyun Bin's permission. According to Section 64, Number 1 of the Bills of Exchange Act 1949, a check that has been materially altered without consent is generally invalid. However, if the alteration is not obvious and the check is in the hand of a holder in due course, it may still be valid but according to its original term. In this case, Won Bin used chemical ink to secretly change the pay's name on the check from Sedap Bah Besendian Berhad to his own name. This is considered a material alteration under the law. The courts have also made it clear that banks must follow the customer's instructions strictly. In the case of London Joint Stock Bank versus Macmillan and Arthur 1918, it was held that if a check is paid in a way that doesn't match the drawer's intention, the bank is liable. Similar to the Malaysian case Bank Negara Malaysia versus Muhammad Ismail and Ors, 1992, the court emphasized that banks must exercise due care when verifying checks to avoid fraud or unauthorized changes. So, if Rupa Banks was the paying bank, it had a responsibility to examine the check carefully before making any payment. The fact that the fraud was difficult to detect does not automatically free the bank from liability. To conclude, Rupa Bank may be legally liable under Section 64, Number 1, for failing to detect a material alteration made without the drawer's permission. If the bank processed the check and failed to verify its authenticity, it may have breached its duty to the customer, Mr. Hyunbin. Therefore, Rupa Bank could be held responsible for the RM 10,000 loss, unless, of course, Jutta Bank was the actual paying bank in the situation.
Assalamualaikum and hi, my name is Nur Amira binti John Elias Jamil, metric number BB3310397. For next issue is whether Ropa Bank is liable to cash a check with a Fox signature even though Mr. Lazi, one of the officer, had suspicion about the signature. The main section from the Bills of Exchange Act 1949 apply for this issue. Firstly, Section 24 states that a forged or unauthorized signature is wholly inoperative. This means no one can get right to enforce the check if it's based on that signature. Secondly, under Section 85(1) provides that a banker who receives payment for a customer must act in good faith and without negligence. Based on the case Leon's Bank Ltd versus E.B. Savory & Co. 1933, a banker is considered negligent if their action falls below the standard of care expected of reasonable bankers, and they must protect both the bank and the true owner of the check from fraud. Similarly to case Marfani versus Midland Bank Ltd 1964, a reasonable banker with proper knowledge of their customer and the circumstance should have suspected that the customer was not the true owner of the check. Applying this principle to Ropa Bank situations under Section 24, the check is legally inoperative because of the forged signature. Although Section 85(1) could protect the bank if it acts in good faith and without negligence. That protection does not apply here. Mr. Lazi admits having suspicion about the signature but still went ahead and cashed the check. By choosing to ignore that suspicion, Ropa Bank clearly failed to meet the expected standard of care, and this shows negligence. In conclusion, Ropa Bank is likely to be held liable for cashing a check with a forged signature. The negligence of its officer, who ignored clear suspicion, means the payment was not made in good faith and lacked reasonable care. Therefore, the bank is not entitled to protection.
Hello, my name is Nur Ain Sofia binti Abdul Karim, and I would like to present about last issue in this case, which is whether Rabiator, the real holder of the check, can sue Ropa Bank for collecting and depositing the stolen value of the check into the Robert's account. This involves examining whether the bank breached its legal duty under Section 85(1) of the Bills of Exchange Act 1949 and whether it acted without due care and good faith as required by banking law. Under Section 85(1) of the Bills of Exchange Act 1949, a collecting bank must act in good faith and without negligence when handling checks for its customers. If the bank fails to verify the identity of the depositor or the authenticity of the check and a fraudulent transaction occurs, the bank may be held liable for wrongful collections. According to common law, especially in cases involving high-value deposits by new customers, bank must exercise due diligence. In Morrison v. London Country and Westminster Bank, 1914, the court ruled that a bank could be liable in conversion if it permits a check to be collected against the rights of the true owner. Another important Malaysian case is United Asian Bank versus Tai Kuan Yarn Trading 1991, where the court stated that banks must verify customer identity and confirm the validity of check transactions to prevent fraud. In our scenario, Ms. Jana, an officer at Ropa Bank, allowed Robert to open an account and deposit a Rm20,000 stolen check without proper verifications. Roberto, the true owner of the check, had not authorized the transactions. The bank failed to verify Robert's identity, investigate the legitimacy of the checks, or question the suspicious nature of such a large deposit. These failures amount to negligence under both sections 85(1) BIA and common law. In conclusion, Roberto has strong legal grounds to sue Ropa Bank under both section 85(1) of the Bills of Exchange Act 1949 and common law principles. The bank's failure to verify Robert's identity and detect the alterations of the payee's name clearly amounts to negligence and a breach of its duty as a collecting banker. As a result, Roberto suffered a financial loss of Rm20,000 and is entitled to claim damages from Ropa Bank. Given these facts, it can be confidently argued that Ropa Bank is liable due to its failure to act in good faith and its non-compliance with statutory and banking standards. That's all from our group. Thank you.